kgethollo le melawana ya baqosuwa le hape wa hlalosa gore go na le dintlha le melao le ke latelwa e le kgatlhanong le ditokelo tsa baqosuwa ka mokgwa a dintho di le daetsana ka teng.
It was further put to him whether it was justifiable for a presiding officer to recuse herself due to the maladministration of the state. The state witness did not provide an answer. It was further put to him that the comment made by me on the day was what I experienced as same was said in my judgment, and the state witness says it was not so. Sorry, I'm sorry. It was further put to him whether it was justifiable for a presiding officer to recuse herself due to the maladministration of the state. The state witness did not provide an answer. It was further put to him that the comment made by me on the day was what I experienced as same was said in my judgment, and the state witness said it was not so.
o ileng a bua go tsantsha ka bopaki o na le dipotso tse ileng ba mo botsa tsona mabaping a se ileng sa bua ke moatlhodi le hape wa hlalosa gore le se le kgatlhanong le molao go tsamaisa tsamaelane le molao wa dipuisano tsa molato.
The court now looks at the jurisprudence pertaining to recusal. The court is privileged as it is guided by a plethora of cases that have canvassed the issue of recusal. As it is the common law principle that no one should be a judge in his or her own case, this is the basis upon which the rule against bias or apprehension of bias was founded. It is also pertinent to mention that whenever the issue of recusal rears its head, the two very important aspects arises. The first one being the presumption of judicial impartiality, which has been described as a cornerstone of our legal system.
moatlhodi o tla tshoswa kgotsa o tla tswela pele jaaka moatlhodi mo dipuisanong tsa molato le hape ya ntlha e shebiwang ke gore a nna moatlhodi o na le leeme kgotsa o na le kgethollo mo dipuisanong kgotsa mosekeng a molato.
And the second test that to be applied to determine the circumstances in which a recusal application should succeed or fail. Now, the seminal case of the President of the Republic of South Africa versus South African Rugby Football Union, the test for recusal was succinctly formulated, and it was stated that the question is whether a reasonable, objective, and informed person would, on the correct facts, reasonably apprehend that the judge has not or will not bring an impartial mind to bear on the adjudication of the case, that is, a mind open to persuasion by the evidence and the submissions of counsel. The reasonableness of the apprehension must be assessed in the light of the oath of office taken by the judges to administer justice without fear or favor, and their ability to carry out that oath by reason of their training and experience. It must be assumed that they can disabuse their minds of any irrelevant personal beliefs or predispositions. They must take into account the fact that they have a duty to sit in any case in which they are not obliged to recuse themselves. At the same time, it must never be forgotten that an impartial judge is a fundamental prerequisite for a fair trial, and a judicial officer should not hesitate to recuse him or herself if there are reasonable grounds on the part of a litigant for apprehending that the judicial officer, for whatever reasons, was not or will not be impartial. Close quote.
tlhaloganyo e tshwanetse go sebedisiwa kgotsa ikanyo bo bueng ke batlhodi go tsamaisa toka gantle le kgethollo kgotsa letsogo le go ya ka go ripella le ka tsebo ya molao e ba go tlileng yona go tshwanetse go shebiwa dintlha tsa molato ga o sa kgetholle go ya ka se moatlhodi nahanelang sona o tshwanetse go gopola gore o na le mosebetsi jaaka moatlhodi go mamela melato gantle le go kgetholla baqosiwa le go shebisisa.
I further refer to the case of Sakao versus Ivan and Johnson Limited, where the court stated that the grounds for recusal require either A, proof that a judicial officer is actually biased, or B, an apprehension of bias on the part of the judicial officer, and whether such apprehension is that of a reasonable, objective, or informed person based on the correct facts of bias on the part of the judicial officer. Close quote.
le gape wa tlhalosa moatlhodi o ya ka molawana o ile wa bewa mo molatong o tshwana le ona o kopanetseng ona gore o tshwanetse o tlise bopaki bo kgotsofatsang pela ga moatlhodi a ka tloswa setulong sa moatlhodi bo bontshang gore moatlhodi ke motho ya leng kgethollo kgotsa o senang boitekanelo ba gore a ka mamela dipuisano le hape le gore a ka seke a ka kgona go ka qeto gantle le kgethollo o na le dintlha le bopaki bo tshwanetseng go tlisiwa pela ga lekgotla le kang ka qeto gore a na moatlhodi theosa setulong kgotsa ga a theosiwe setulong sa boatlhodi.
Section 165 of the Constitution unequivocally reassures the public that judicial officers are deemed to be impartial when dispensing with the judicial functions and or duties. Section 165(2) emphasizes that the courts are independent and subject only to the Constitution and the law, which they must impartially and without fear, favor, or prejudice. This section is jointly read with Section 8(1) and Section 34 and Section 35 of the Constitution.
Le hape o na le dintlha le melawana e tla latelwang e tla kgotsofatsa lekgotla kgotsa e tla bontshang gore a na moatlhodi ke motho ya kgethollwa kgotsa o ntsha atlhola mabapi a go kgetholla le o sa atlholwe le hape wa tlhalosa moatlhodi gore go na le melawana le dintlha tsotlhe tse tshwanetseng le go latelwa le melawana e ka shewang pela ga lekgotla le ka qeto gore a na moatlhodi tla tswela pele kgotsa a ka se tswele pele mabapi a o tswela pele dipuisano tsa baqosuwa.
As the then Chief Justice Mboro expressed in the case of Burnett versus Absa Bank, the presumption of impartiality and the double requirements of reasonableness, the presumption of impartiality is implicit, if not explicit, in the office of a judicial officer. This presumption must be understood in the context of the oath of office that judicial officers are required to take, as well as the nature of the judicial function. Judicial officers are required by the Constitution to apply the Constitution and the law, impartially and without fear, favor, or prejudice. Their oath of office requires them to administer justice to all persons alike, without fear, favor, or prejudice, in accordance with the Constitution and the law. And the requirement of impartiality is implicit and if not explicit in Section 34 of the Constitution, which guarantees the right to have disputes decided in a fair public hearing before a court, or where appropriate, another independent impartial tribunal or forum. This presumption therefore flows directly from the Constitution. As is apparent from the Constitution, the very nature of the judicial function requires judicial officers to be impartial. Therefore, the authority of the judicial process depends upon the presumption of impartiality.
pela ga o ka qeto ya gore a na moatlhodi o na le kgethollo kgotsa a na se na kgethollo mabapi a qeto ya ikileng mo dipuisanong kgotsa go sekwa ga molato go na le dikanyo bo baatlhodi ba bonkang le gape ba tshwanetse go netefatsa gore ba latela melao e ka tlasa melaotheo go netefatsa gore dintlha tsotlhe ba ipontsha ba ise batho ba e leng kgethollo kgotsa na ke batho ba leng kgethollo mabapi a diqeto tse ba dinkang mo melato e sekwang pela lekgotla la melao.
Now, application of the legal principles to the facts. Before I delve into applying the legal principles discussed above, I would however like to address the procedure that was followed regarding this application. The Constitutional Court in the Safu case informs us that the usual procedure in applications for recusal is that counsel for the applicant seeks a meeting in chambers with the judge or judges in the presence of her or his opponent. The grounds for recusal are put to the judge, who would be given an opportunity, if sought, to respond to them. In the event of recusal being refused by the judge, the applicant would, if so advised, move the application in open court.
le dintlha tse itseng tse tlasa molaotheo tse neng a di shebisisa pele ga nka ka qeto mabakeng a gore na o tla theowa setulong kgotsa ga se theowe setulong jaaka moatlhodi mo molatong.
In this case, the procedure used by the state significantly deviates from the established practice. No attempt was made to engage with me, either in writing or in chambers, before the application for my recusal was presented. I was not provided with an opportunity to evaluate the reasons for my recusal, nor was I given the chance to present any facts on record. Be that as it may, the facts relied upon by the state or the inferences sought to be relied upon are drawn from the evidence of the state witness, Mr. Vilakazi. I agree with the Apex Court when they said that, and I quote, "At the very outset, we wish to acknowledge that a litigant and her or his counsel will find it necessary to apply for the recusal of a judicial officer has an unavailable task, and the propriety of their motives should not lightly be questioned. Where the grounds are reasonable, it is counsel's duty to advance the grounds without fear. On the part of the judge whose recusal is sought, there should be a full appreciation of the admonition that he or she should not be unduly sensitive and ought not to regard an application for his or her recusal as a personal affront." Close quote. It is evidently clear that the state applied for my recusal in this matter, in that they say I've shown an apprehension of bias as per the testimony of the state witness, Mr. Vilakazi. They therefore want to disqualify me to hear the pending bail application on new facts, and therefore should I do so, I will be prejudicing the state. It is also correct that the judicial officers enjoy and have jurisdiction to determine applications for their own recusals, and if the judicial officer, after having dealt with their recusal application and refuses such application, and it is found that the decision was incorrect, this can always be corrected on an appeal. From the pub. Sorry, I'm going to speak louder. It is evidently clear that the state applied for my recusal in this matter, in that they say I have shown an apprehension of bias as per the testimony of the state witness, Mr. Vilakazi. They therefore want to disqualify me to hear the pending bail application on new facts, and therefore should I do so, I will be prejudicing the state. It is also correct that judicial officers enjoy and have jurisdiction to determine applications for their own recusal, and if the judicial officer, after having dealt with the recusal application and refuses such application, and it is found that the decision was incorrect, this can always be corrected on an appeal. Inasmuch as I was not afforded an opportunity to evaluate the reasons for my recusal, and in evaluating the evidence of the state witness, the court is then expected to address the said allegations, or in this context, the said evidence presented. However, I am of the view that I can only maneuver within the framework of the evidence presented, which is quite limiting. The said evaluation is against the backdrop of the test laid out in the Safu case.
le hape wa hlalosa moatlhodi gore ena a ke a fiwa monyetla wa gore a ikarabele mabapi a kopo ya gore a theoswe setulong, le hape wa hlalosa gore go tla sebetsa ka bopaki bo boleng pela hae, le hape wa hlalosa gore bopaki bona ha bo enough kgotsa ha bo kgotsofatse lekgotla gore le ka nka qeto e bonahalang kgotsa e itseng mabapi a kopo e itseng.
I reiterate Judge Kuhn's sentiments found in the case of S versus Zuma and another, and this is found in paragraph 28 of his judgment, that, and I quote, "Our law does not insist on the proof of actual bias on the part of a judge. The appearance or a reasonable apprehension of bias, if proved, is enough to vitiate the proceedings. As has been said, the court will not inquire whether the judge did in fact favor one side unfairly where the allegation is reasonable apprehension. Where the impartiality of a judge is in question, the appearance of the matter is as important as the reality. Thus, it is no answer for the judge to say that he is in fact impartial, that he abided by judicial oath and there was a fair trial. The administration of justice must be preserved from any suspicion that a judge lacks independence or that he is not impartial. If there are grounds which would be sufficient to create in the mind of a reasonable man a doubt about the judge's impartiality, the inevitable result is that the judge is disqualified from taking any further part in the case. No further investigation is necessary, and any decisions he may have made cannot stand." Close quote.
Bo tshwanetse ho tlisa ka bopaki bo bontshang le bo kgotsofatsang gore moatlhodi pila ba motho o na le leeme kgotsa yo le kgethollo mo dipuisanong, le bopaki bo bo tshwanetseng ho kgotsofatsa pela ga lekgotla le ka fumana moatlhodi le motho o na le kgethollo mo dipuisanong kgotsa ho sepeng ha molato, le hape wa hlalosa gore bopaki bo bo tshwanetse bo kgotsofatse gantle le pelaelo, le hape ha bo kgotsofaditse lekgotla ke moo he lekgotla le ka nkang qeto gore a na ba tla theosa moatlhodi mo setulong kgotsa ba ka se mo theose setulong, le hape le diqeto tsa ileng a di nka mo dipuisanong tsa melato eo di ka phumulwa haebaneng moatlhodi o fumana a na le molato kgotsa ba fumana a leng kgethollo mo molatong o sekwang pelaelo.
Did the state discharge the onus that rest on them, that Mr. Vilakazi's apprehension of bias is a reasonable one? His testimony rests on 3 incidences, which was the day of the said bail application, the incident when the accused number 1 appeared before court without a requisition, and the last incident that he said happened on the 2nd of September 2024. Again, I don't want to descend into the arena of he said, she said, as I was not given an opportunity to address the said application due to the state adopting a bizarre procedure that is vastly different from the one laid down in our legal jurisprudence. But it is imperative to correct the state witness in providing the accurate proceeding which may well vitiate his testimony or show the lack of merit in the state's application.
Moatlhodi a theoswe setulong le mabapi a le dintlha tse ileng da etsagala gale ka letsatsi le moqosi wa ntlha ile a tlisa pela lekgotla ho sa tsebiwe hobaneng morao a gore kopo ya hae ya ho lekola ka pele e sa dumela, le hape ha ona bopaki bo itseng kgotsa bo kgotsofatsang bo tlatsang hobaneng kopo ena ile ya kenywa gore moatlhodi a theoswe setulong.
Now this court is a court of record. What happens in it is duly recorded, be it mechanically or on the charge sheet or both. I turn now to the first incident of the 19th of August 2024. It is rather surprising that the state witness, Mr. Vilakazi, informs this court that the conversation that took place was in an open court with court staff present. He conveniently removes himself from this participation of what is termed by him a general discussion amongst colleagues.
Le hape lekgotla lena ke lekgotla le sebetsang ka ho recorda dipuisano, le hape wa hlalosa gore ntlha ena ile ya etsala ka di-19 tsa August, le hape mo ile go ba le dipuisano teng magareng ga basebetsi ba lekgotla, le hape wa hlalosa moatlhodi gore yena Mr. Vilakazi na wa intsha mo mabaping a karolo e leng a e bapala mo dipuisano tse le la etsana mo le gotleng ka lona letsatsi.
Now, it is not unusual or uncanny for a court to repeat its findings, which was read onto the record, whether verbatim or in general conversation, after having heard the matter. He therefore paints a picture to this court that something wrong happened which it did not. It is also strange that he would say, I invited the legal practitioner to my chambers in full view of the court and its court staff when the invitation was not extended to him. This court will not allow the state witness to distort what transpired and what did not transpire to formulate an ill-considered narrative. There is no basis for the court to make such a comment. It is further by his own version that he is not sure whether the court met with the defense legal representative. Therefore, it is safe to conclude that he or is or was speculating. An objective person, or should I state that an individual of his professional caliber would in the least provide evidence to support his assertion. I mean, it is common cause that his tools of trade and of functions is to provide irrefutable proof when he fulfills his duties, but in this case, he operates on speculation. It was put to him in cross-examination that he knew about the date of the 2nd of September. He denied saying. However, it is important to note that in his testimony he mentioned that the legal representative of the accused kept on coming to his court and omitting him to discuss the intention to bring bail application on new facts. Again, this is rather peculiar to even try to reconcile his denial but then concession of the same fact. It is further not in dispute that I had taken leave of absence from office when this conversation of intending to bring a bail application that he speaks of. I cannot fathom how I would then conspire such a plan. He tells the court that by the accused appearing on the 28th of August 2024 without his knowledge and or requisition, it then satisfies himself that the purported comments made by myself on the 19th of August 2024 justified the appearance of accused number 1. I have stated above that this court is a court of record. It is therefore prudent to appraise the state witness, Mr. Vilakazi, with the facts of the incident of the 28th of August 2024. As he correctly testified that District Court number 3 is not his court, and he was in his court in DC1. It is also common cause that the state witness is not the resident public prosecutor of DC3. The events of that day were just as bizarre to the then court officials of DC3. Accused number 1 appeared before this court without a warrant of detention, a J7, or requisition form, which in the normal course is duly completed by the state. The court inquired from the resident public prosecutor of DC3 as to why the anomaly. There was no answer provided. The court record is reflected in the charge sheet stating that There's no reasons advanced why the accused is before court today, and a signed requisition form was requested by the court. Till today, it has not been provided. I must note that the legal representative recorded on the charge sheet on behalf of accused number 1 on the 28th of August is not the same legal representative who have handled this matter since its inception.
requisition form e re tsebisang gore ke mang o ntshitse molawana wa gore moqosuwa a tle pela lekgotla o sena tsebo le hape wa hlalosa ho fihlela ka jeno a re so fumane wa hlalosa moatlhodi gape gore moeledi kgotsa agente ya moqosuwa ka letsatsi leo mo ne a tlile ka lona a se moqosuwa o ile a qala ho sekwa kgotsa ya kopo ya hae ya lokela pateng ke ba ke di agente tse fapaneng a se motho.
So based on the maladministration on the side of the state, on that day, the state witness wants to paint the picture that the court orchestrated that incident, so that satisfied him that there is a reasonable apprehension of bias. Now the third incident of the 2nd of September 2024, he states that he was in the company of the legal aid practitioner of his court when he passed by my chambers, and I uttered the said comment. It raises suspicion that the state witness of his professional caliber does not call the said person he states that he was with on the day. It must be noted that indeed so, I was moving chambers. It was also necessary to point out that the state witness selective amnesia. He tells us that he approached me and inquired about the bail application on new facts that he knew nothing about, as the date was not arranged with him. But all communication was canvassed with his colleague of the District Court number 3. How then does the court grant him indulgence when he sought a postponement last week to readily prepare the bail application that was to be held on the 9th of September, if it is his testimony that I uttered the words, "Do not worry about it, your colleague will do it, it is not a big deal"? Would the court not have then insisted on the day that his colleague proceed with the matter on the 2nd of September if something was underhanded or sinister? He then questions his evidence that I uttered the words, "Why is he being harsh?" or to the accused. There is no basis nor merit to this submission, as it is evident that the state witness sought to purport or cook a narrative that is an apprehension of bias on the side of the court. The conduct of the state witness following the said incidences and who he reported the matter to, and failing to approach me and or his seniors, really leaves us all here questioning his motives. I will not belabor on that point because the cross-examination of the defense exposes the shortcomings of the state witness.
go baqosuwa mo dipuisanong tsa beili kgotsa kopong ya bone ya lokola ka beili le a to a tlhalosa gore dipuisano kgotsa dipotso tse ne ba mo botsa tsona jaaka a ntsha bopaki ile wa bonagatsa gore ena ke motho ya senang nnete kgotsa a sena bopaki ba dintlha tsotlhe tsa qosang moatlhodi mo dipuisanong tse.
It is clear that the state witness apprehension is not reasonable. It is not objective and it is not based on the correct facts. I would have taken no issue but to recuse myself if the evidence presented before the court by the state was reasonable and objectively showed that I may be biased going forth with the bail proceedings. I concur and agree with Mr. Ramavoya in his submissions that an application for recusal is a very uncomfortable exercise because indeed so, I must take a magnifying glass and thoroughly examine my alleged conduct. What makes this exercise extremely uncomfortable is that the evidence provided has cast doubt on the integrity, credibility, and judicial independence of the court. The same integrity which is provided, promoted, and protected by the Constitution. The said impugning of the court further fuels and perpetuates the narrative that the public will not have confidence that the courts are independent and impartial. I must add that it is the prerogative of any litigant to bring in the said application, but same should be carefully considered as the provision of Section 1652 of the Constitution are sacrosanct to any judicial officer who have taken the judicial oath of office. I refer to Article 2.5 of the Banga Law Principle of Judicial Conduct, which states that a judge shall disqualify himself or herself from participating in any proceedings in which the judge is unable to decide the matter impartially or in which it may appear to a reasonable observer that the judge is unable to decide the matter impartially. This is echoed in Article 13 of our country's the Code of Judicial Conduct of Judges, which stipulates that a judge must recuse him or herself from a case if there is A, real or reasonably perceived conflict of interest, or B, reasonable suspicion of bias based upon objective facts, and shall not disqualify himself or herself based on trivial or insufficient grounds. This is the same standard equally applicable to magistrates. It is also surprising that the state would forthwith bring this application when they have been successful in all their endeavors with this matter. Their defense submit that the state is deliberately frustrating their client and that this application exposes the maladministration on the state's part. They are correct to state that the presiding officer should not be used as a tool to settle scores. The court is dumbfounded by this application. It is also pertinent to remind the state witness, Mr. Vilagazi, of his oath of office. He is a legal practitioner, and therefore his powers, duties, and functions are regulated by the National Prosecuting Authority Act, as well as their legislative policies. Furthermore, the Code of Conduct for all legal practitioners highlights the expected standard required by saying.
kgotsa melawana e tshwanetseng go latela ka tsela e nepagetseng mabapi le go kenya dikopo tse tshwanang le tsena mo dipuisanong kgotsa go setlweng ga molao.
To mention just one, Article 3.1 of the said Code of Conduct requires a legal practitioner to maintain the highest standards of honesty and integrity. The court expects legal practitioners in executing their duties to uphold the values and objectives found in the said Code of Conduct for legal practitioners. I do not expect less from the state witness, Mr. Vilakazi, as he has a duty to fulfill. I am enjoined by my oath of office to adjudicate cases and minister justice without fear, favor, or prejudice, and it shall not be dissuaded or be prevented, and I shall not be dissuaded or be prevented from doing so based on unsatisfactory evidence that have been provided by the state. Public perception is of paramount importance, as they must be left with the reassurance that the court remains impartial and maintains its judicial integrity. I am reminded of the Sepedi idiom that perfectly describes the position that the state witness, Mr. Vilakazi, has placed me in. Ke kgomo ya moshate, wa e gapa o molato, wa e tlogela o molato, loosely translated that I'm damned if I do and I'm damned if I don't. I therefore conclude that the state, with the evidence they presented, have not discharged the onus resting upon them to show that the apprehension of bias is reasonable, and I also conclude that the double requirement of reasonableness that the application of the recusal test import is not discharged. The application for my recusal is hereby dismissed.
As the court pleases.
Yes, Ms. Madam.
As the court pleases, Your Worship, as I have gone through the charge, Your Worship, I have realized that in terms before this matter was brought before the Honorable Court, the defense was intending to bring bail on no facts, Your Worship. However, as much as I was not the resident prosecutor for this matter, nothing was liaised to me. I just had it in passing. So I don't know at this point in time where the defense stands before we proceed.
Advocate Lamine.
Thank you, Your Worship.
Are you proceeding or?
We are proceeding, Your Worship.
Ms. Madam.
As the court pleases, Your Worship, after the judgment that has been brought before this Honorable Court in terms of the application which was brought to Worship, Mr. Vilakazi was the one that was dealing with this matter. I just was interject to jump in and take over at this point in time. But however, not for me to proceed with the formal bail application, Your Worship, to be in for the judgment in just to be laid before this Honorable Court by the President.
I don't know now, because on Monday, Mr. Ramavuya, there was consensus from the state and the defense that no matter how either I recuse myself or I do not recuse myself, we will proceed today. And Mr. Ramavuya stated that you would then proceed. Mr. Vilakazi has fallen off the case.
As the court pleases, Your Worship, yes, indeed, that is what has been said at the side of the Office of the NPA, Your Worship, that the matter will proceed to the Your Worship.
All right.
On that note, Your Worship, state the request this honorable court to take a short adjournment, Your Worship.
I see it's
So that
12:30.
Put our house in order.
I see it's 12:30. I don't know. What time do I come back? Are we going to work through lunch? I don't know what's the arrangement.
Your Worship, she has not given time the adjournment. We need to know, is it 20 minutes, 30 minutes to deal with that aspect? We cannot take too long. That's the issue that we place on record. So if you give us time to say adjournment for this time.
Ms. Mudau in the hot seat. You would have to tell us.
Your Worship, it is also a concern that keeps on repeating itself. And we are going to have the same case again, whereby we'll come here late, be left with only 30 minutes to present our case and be told that there is no time. They must take the accused back to the cell or anything. That's why we are insisting on saying how long do they need for them to tell us to adjourn. We need to know the period of time, because if not so, it's going to be the same issue repeating itself of us being delayed.
I don't want to dictate, because I say it's 12:30. I've got no issue working through lunch. You just inform me, I come back, we'll proceed. The state is dominus litis. They must tell us. Ms. Mudau, you said that you've just been thrown into this case, so I don't know how long you will need. But I also hear the defense's submissions that we can't repeat what's been happening. It's not fair on behalf of the accused, and also not fair on the state as well.
Definitely so, Your Worship. On top of that, I cannot speculate.
So, I don't know. Will I be called or what?
We will do so, Your Worship. As usual, when we're about to start, we will call the magistrate before the honorable court and we will proceed.
Maybe let's set timelines. Is that fair? That we don't
I'm
wander
in
into,
court hands.
that we don't wander into the darkness and just not know.
I'm in court hands, Your Worship.
As I stated, I've placed that. I've got no if you come back at 1 o'clock, I've got no issue. You can come back at 1 o'clock. If you come back at 2 o'clock, I've got no issue. You can come back at 2 o'clock. You just inform me. Is that fair?
As the court pleases.
All right, then the court will take a short adjournment. Court adjourns.
All right.
Good afternoon, Your Worship. Good, thanks, and you? Does Your Worship have the charge sheet so I can place the matter on the roll? The docket is with investigating officer. Okay, police officers. Your Honor, can I proceed?
Your Worship, the bench is broken. They won't be able to sit, but the bench is broken. They can sit, Your Worship.
On record, Your Worship. Calling case number TC2/2022, the matter /24, the matter between the state versus Paseka France Motsoeneng, applicant number 1, and Vincent Camilot Baloy, applicant number 2, seated at the Palm Beach Magistrate Court in the district of Plymouth Central. Today's date is the 11th of September 2024. Appearances are the same as before. Matter before court. Okay, Your Worship, please assist. I'm not sure. Proceed. Well, bail on effect. I'm not sure.
Good afternoon, Your Worship. Your Worship, this is bail on new fact. But I want to raise technical issues, the question of law. First, Your Worship, that's the first thing that I want to raise. And if the court agrees with our position, then the honors shift to the state. If that fails, Your Worship, then we will deal with our main application, if the court so permit. From the beginning, Your Worship, we said the Schedule 5 while applicants don't agree with it, but that's the Schedule 5, and we believed that the prosecution will be able to do two things, Your Worship. In terms of Section 60, 11 capital A in bracket, A, small brackets, A small in bracket. We say, Your Worship, the prosecution has not provided a certificate or written confirmation regarding Schedule 5 of the Criminal Procedure Act as amended. Therefore, fail in its duty as an officer of the court. Your Worship, we submit that if they cannot produce that certificate, in terms of Section 60, 11, capital A in bracket C, which will be mitigate their failure, Your Worship, they have to adduce evidence to say it is a Schedule 5. Will ask, Your Worship, that all the offenses the applicant are charged with are not part of the Schedule 5. So in short, they should have been charged with Schedule 1. And if the court will agree with defense on that, that will be a Schedule 1, the honors shift to the state to show why the applicant should not be granted bail. It's important, Your Worship. The state is fully aware of that situation. They are aware that they suppose if any Schedule 5 or Schedule 6, they must provide. Perhaps let me read this section on record, Your Worship. It's 11, Section 60, 11, capital A in bracket, small a in bracket. If the Attorney General intend charging any person with an offense referred to in Schedule 5 or 6, the Attorney General may, irrespective of what charge is noted on the charge sheet, at any time before such person plead to the charge, issue a written confirmation to the effect that he or she intend to charge the accused with an offense referred to in Schedule 5 or 6. Your Worship, if prosecution could not provide that certificate or confirmation, the legislator made it an escape route for the prosecution. And you find it in 11, capital A in bracket, small c in bracket. Whenever the question arises in a bail application or during bail proceeding, whether any person in charge is charged or is to be charged with an offense referred to in Schedule 5 or 6, a written confirmation issued by Attorney General under paragraph A shall upon mere production at such application or proceeding be prima facie proof of the charge to be brought against that person. So if that certificate is not there, Your Worship, they have to lead evidence to say it's a Schedule 5 and at their own peril. Your Worship, before this court, I submit that there is no certificate or written confirmation from the Director of Prosecution or Attorney General, as may be the case. And in that situation, Your Worship, the state has not shown that this is a Schedule 5 offenses. And if Your Worship want me to deal charge by charge, I can do that, Your Worship, to show that this is not a Schedule 5 offenses. Your Worship, what the state provided before this court in terms of their own
Bishop, I'm not too sure what's the purpose of all of this. Isn't, as far as I know, this is an application on bail on new facts. So far, my colleague has been addressing the court, trying to disprove the prosecution that this is a Schedule 5. When are we getting to showing that there's new facts, and then these new facts warrant the accused person to be released on bail? This is just prolonging and delaying the process, Your Worship, and it's actually a waste of time. Not unless if Your Worship is of the view that this is indeed necessary, but from the state side, I find it totally unnecessary. This is what my colleague should have raised initially when the matter was for bail application. Now, few weeks later, he brings this up. And in fact, Your Worship, just to state, it was my colleague, as per agreement with the defense, that this is a Schedule 5 application. And the application went its entire process to a point where bail was denied. So now it's not the time now to actually discuss whether this is a Schedule 5 or Schedule 6, and there should be a certificate. That should have been done before. Today is for facts, new facts to be placed for the court decide whether these are new facts, and if they are new facts, and if there are new facts which are relevant, then do they warrant the accused person, or rather applicant A, applicant 1 and applicant 2 to be released on bail? What my colleague is doing now, I do not understand.
Your Worship, I don't understand what my learned friend is trying to achieve. I have addressed Your Worship to say I'm raising a question of law, and I've shown that he's not objecting, he's not saying it's not a question of law. Now, Your Worship, I've read Section 60, 11A, in bracket, A, in bracket. Clearly, I've shown that the Attorney General at any time can raise this issue, to say that the status of the schedule and issue that at any time, Your Worship. Now, my brother here, he raised an issue purposely delaying my submission or trying to derail me from my submissions. Your Worship, the applicant have a right to the rule of law. This country, Constitution, promote the rule of law. The law provide some protection that people cannot just be, because somebody think it's a Schedule 6, then he charge them with Schedule 6. Somebody think it's a Schedule 5, he charge them in Schedule 5. The law provide mechanism how to deal with this issue. And the Act itself, Your Worship, it respect the Constitution of this country, because the Constitution does not allow a person to remain in detention unnecessarily. Now, Your Worship, I've shown that this particular issue is a new fact on its own, let alone what he's talking about. That's a new fact. That they have not produced a certificate is a new fact, Your Worship. Having said so, Your Worship, is trying to run away from providing the certificate and either lead evidence to prove that yes, it's a Schedule 5 matter. And I've said, Your Worship, before I deal with that, why must I waste court's time to go to new facts when actually it's not a Schedule 5? Your Worship, he alleged that we agreed. And Your Worship, there was no agreement. In the affidavits of the applicants, they have said it is Schedule 5, but they don't agree with that. So that should have been a signal to prosecution to say we need to get a certificate because this issue will be raised again. There is no certificate, Your Worship. If there was, you would have stood up and said there is a certificate, Your Worship, and hand it over to be an exhibit. And the section is very clear. If you produce that certificate, the matter ends there and there. Prima facie, it is a decision of the Director General or the Attorney General that it's a Schedule 5. As we stand here, Your Worship, there is no evidentiary proof that it's a Schedule 5. We cannot take shortcuts. If there is an issue of the law, we must bring it up. And I've made it clear, Your Worship, that if we fail on that part, we will now go to the second issue, presenting you in terms of Section 65 in bracket 2 of the Criminal Procedure Act that give authority to bring new facts. Why should we waste the court's time if it's not a Schedule 5 and then we deal with Schedule 5 issues? We have wasted so much time for the court. We have wasted so much time for the applicants to sit in prison without being granted bail. Your Worship, if my friend is able to argue against or in support of Schedule 5, then you can argue, Your Worship, and then you make your ruling, and then we proceed.
Excuse the court, Your Worship. Seeing that my colleague needs a certificate, then maybe the matter can be adjourned so that same can be provided to the defense. That will clarify the issue even further beyond any doubt. Therefore, Your Worship, the state humbly implores this court to provide it a chance to go to the DPP, provided with to provide the defense with the certificate that they requested. We do not have it at the moment, Your Worship. We were not aware that such an issue would be raised. We were never initially warned by the defense that such an issue would be raised, and therefore the certificate was not provided to myself or my SPPs, Your Worship. And therefore the state is of the view that postponement, a short adjournment, Your Worship, is suitable for purposes of providing this court with a certificate, Your Worship. However, the state wishes to state that it's rather disingenuous of my colleague to now come today and say there was no agreement. Then why did they go along with bail application on the basis of Schedule 5 if they were not in agreement that it is a Schedule 5 offense, Your Worship? And it's not a new matter, it's not a new fact, Your Worship. This is, if at all they knew this, they knew it before. So you can't say something that you knew before and never raised it before and you raise it now. It's a new fact. It's not a new fact. But, Your Worship, if my colleague wishes for the state to provide it with provide the defense with a certificate, Your Worship, the state will be left with no choice but to ask for a postponement, Your Worship. The state does not know for how long will that certificate be will it take for it to be provided, Your Worship. Please look. No, Your Worship. Yes. It's not a, Your Worship. Your Worship, the section says the Attorney General, rather being saying, to put it differently, the DPP, Director of Public Prosecution, may issue a certificate. May, not shall, issue a certificate. However, seeing that my colleague is impressing upon this issue and is being emphatic so much that that the state is of the view that to clarify issues conclusively, then we need an adjournment to provide him with a conclusive evidence coming from the TPP that this is a Schedule 5 matter, Yoshi. The state was under the impression that today things will proceed. However, if my colleague wishes for the state to request for an adjournment, Your Worship, the state will be left with no choice but to request for an adjournment. But I do acknowledge the Director of Public Prosecution is not obliged, may, not shall provide the certificate.
A and C.
There's no A, it's B, and C.
Yes, the
B
A.
says A, C says sharp.
Yes,
Not correct.
yes.
Yes. A, capital letter, small letter A said, if the Attorney General intends charging any person with an offence referred to in Schedule 5 or 6, the Attorney General may, irrespective of what charge is noted in the charge sheet, at any time before such person pleads to the charge, issue a written confirmation to the effect that he or she intends to charge the accused with an offence referred to in Schedule 5 or 5 or 6. In the state's understanding, C, whenever the question arises in a bail application or during bail proceedings, whether any person is charged or is to be charged with an offence referred to in Schedule 5 or 6, written confirmation issued by the Attorney General under paragraph A shall, upon its mere production at any such application, be prima facie proof of the charge. Shall, yes, if that evidence, if that certificate is there, if the Attorney General has decided, has used his discretion to provide with the certificate, if it's there in the state's possession, mere production thereof shall be conclusive proof. However, current paragraph A says may, not shall. So that Attorney General is not obliged to provide with the certificate. That's the state submission issue. However, if the defense wants the certificate, the state is asking for a postponement, Your Worship, to provide it with the said certificate.
Thank you, Your Worship. The section is very clear. Your Worship, I read the two sections. The first one, may, and if the DPP, is that I'm correct? Oh, I'll stick to Attorney General, what is written here. If the Attorney General may issue at any time, it tells Your Worship that the charge to go to that stage, it must be approved by the Attorney General. And if that's not the case, Your Worship, 60, capital A in bracket, C, small c in bracket, comes up, Your Worship, with a situation that the prosecution must prove whether it is Schedule 5 or not, Your Worship. Now, my friend wants to resort to the old tactics of postponement. Those are old tactics. The issue is that he could put the witness there on the box and state how did he come to say it is Schedule 5. That's the cure. Your Worship, I'm saying this, Your Worship, very clearly, because the Constitution protects any person who's charged for an offense. Offenses, Your Worship, are clearly defined. Now you can't tell me, oh, I'm sorry, Your Worship, I'm saying he can't tell me that a dummy, what's the correct word? This one. A replica AK-47 sold in many shops in around Johannesburg. It's a Schedule 5 offense. He can't tell me that, Your Worship. He can't tell me when a person taking his children from school is a Schedule 5 offense. Your Worship, if I refer you to the affidavit by the police officer. He referred to the weapon as, and it does not describe the weapon effectively. What is the rifle? What are the serial number of that rifle? Are they still there or interfered with? He just tell us one thing, the reference to he tell us about the reference where the matter but he just gives the reference where they've taken the vehicle for ballistics. It doesn't work like that, Your Worship. He must give the type of a weapon that we are talking about to qualify that weapon as a Schedule 5. Your Worship, if they were sure about the type of weapon they are talking about, they would have given the court exactly what the weapon it is. Your Worship, I've introduced that, Your Worship, and just to show you that they have a case to justify, to say it's a Schedule 5. And, Your Worship, as we stand here, this court has been misled in many ways. First, kidnapping. The court has been misled with kidnapping. Your Worship, in this court, prosecution on record said they have a certificate, a court order that granted the mother of the grandmother of the children parental rights. Your Worship, there's nothing like that. There is no such court order. They are misleading the court. J50. People arrested at the police station. What is the need of a J50 when people already at the police station? Another way of misleading this court. Your Worship, I have said, I'm putting this aspect, there is no reason for postponement. The Act provides a mechanism to cure that part. If the Attorney General, as my learned friend has confirmed that he has not done so, there is the place. You must put their witness there to tell us how did he come to Schedule 5. Then we have the opportunity to cross-examine that witness as their own peril. Now they are running for the reality. They want us to give time to go to the Attorney General and say we are asking, why didn't they ask about this thing? From the beginning of the bail application, we have raised that we are not in agreement with the Schedule 5. Now we have find new evidence that is not the Schedule 5. Your Worship, a Schedule 5 semi-automatic rifle. They don't say what type of a rifle. They talk about bullets, but the accused are not charged of ammunition. Talk about ammunition, a rifle and ammunition, but the witnesses are not, or the applicant are not charged with the ammunition. All those things are misleading the court. The court should be independent. And next thing they will come and say the court is biased. We have not complained about the court. We have not raised a single issue when the court went against us. The Victorians are going to complain about the court. Your Worship, this is the point that this court, not tomorrow, not after break, not after adjournment, the evidence is before court. There is no certificate. If we can't lead evidence, the court will have to take our uncontested submission, Your Worship. It's not contested up to now. The court cannot keep on giving them the opportunity to do as they like. Your Worship, let me stop there and allow the court to make its own decision. Yes. Thank you, Your Worship. Yeah. Your Worship, I want first to present a copy of the receipt where the alleged rifle was bought. So it's written, clearly written, Your Worship. It's not. Are you getting that document? Indulgence, Your Worship. Your Worship, a receipt has been obtained showing where this particular alleged AK-47 was bought. Walking customer. Your Worship, shop number 290, China Mall, Amalgam, Johannesburg. That is Your Worship, I just want to give my friend first copies of it before I hand over.
And Your Worship, if I may, another thing, Your Worship, the state is not in possession of this affidavit that's now being handed in as annexures, or a portion thereof is being handed in as evidence. And what evidence is this? Is this now substantiating the fact that there's new evidence? Your Worship, the state is confused as to the procedure going on. It just doesn't make sense. What's my colleague trying to get at? The schedule.
The issue of the schedule.
But then didn't Your Worship say that my colleague should each count, as he said, that
I'm doing that.
every count does not have a share of 5 attached to it? Shouldn't he just go each count instead of showing us slips and receipts of things we don't know about? We don't have any affidavit. We've been asking for this affidavit for a few days. We don't have this affidavit. I don't know what they given to the court.
You were given this thing.
Given the affidavit?
Please. We're not talking about affidavit,
sir,
we're
I'm standing.
talking about evidence. Yes, that's why I started. You are correct, Your Worship. No problem, Your Worship. I wanted to, let me start with count 5.1 in their own document. Because we don't have a charge sheet, Your Worship, will rely on what they put in here. Your Worship, ×2 kidnapping of involving of the Katlehong North affidavit, Your Worship. They are affidavit. That's page 2, Your Worship. ×2 kidnapping involving 2 kids. Your Worship, in terms of schedule, kidnap is not a Schedule 5. But let's leave that, Your Worship. This court had the opportunity to hear whose children are those. And this court came to the conclusion that the father of the children should be released because there was no dispute between defense and prosecution. There is no dispute about whose children are there. Now kidnapping, Your Worship, has no basis. It's weak. It cannot stand. And when I go on, Your Worship, the Children's Court has already dealt with this aspect. And they have said the father must retain the 2 children and the grandmother, maternal side, must retain the other 2 children until the court so decide. So I don't see how such a situation where family fight tend to be Schedule 5 with no death, no serious injuries, how it tend to be Schedule 5. Your Worship, I won't spend too much on that, but I've just given you a signal to that. Intimidation, not less than 3 counts. Your Worship, intimidation is not a Schedule 5. Your Worship, let me put these words in front so that I must not forget that in all these charges, if a person has never been found guilty on them, it cannot be a Schedule 5. Let's go to 5.3, trespassing. Your Worship, trespassing cannot be a Schedule 5. Cannot be. And it's worse a public place where a parent go pick up his own children. That charge is weak, Your Worship. In actual fact, it's just abusing the court system. 5.4, contravention of Section 123B of Firearm Control Act 60 of 2000, failure to produce license for firearm when so requested. It's not a Schedule 5. Failure to produce a license. Can it be a Schedule 5? No, it cannot, Your Worship. I move, Your Worship, to 5.5, contravention of Section 21A. I'll come back, Your Worship, to 5.4. Contravention of Section 20 in bracket 1 and bracket A of PSIRA, working as a security without documents. It's not a Schedule 5. There is no Schedule 5 there. Let me continue, Your Worship. 5.6, discharge of firearm in a building area. It's not a Schedule 5, Your Worship. I don't want to go into the merits, Your Worship, but it's not a Schedule 5. 2 times assault. It's not a Schedule 5, Your Worship. Pointing of a firearm, Your Worship, is not a Schedule 5. In fact, I will argue there was no firearm. Possession of unlicensed firearm, a rifle. That's where, Your Worship, I want to spend some little time, Your Worship, to say this rifle they are talking about, Your Worship, is something that you buy over the counter. It's a replica. And they are so brave enough not to tell the court that we suspect it could be a replica. If they had said so, Your Worship, they would have at least taken the court into their confidence. Your Worship, I have original receipt, which I intend handing over, Your Worship, and a picture of this replica, Your Worship, which was taken at the police station. What is even worse, it was taken at the police station to show that it's a replica. That's why even police at the police station could not bother about where it's left, because it's a replica. If it was a serious weapon, it would have never been taken like this. Here in the picture, you'll see there are replica bullet or ammunition. They are not charged of that because they know exactly that it is not a firearm, Your Worship. And I'm saying this, Your Worship, to say that if police cannot come to court and assist the court to come to the correct conclusion, and they are misleading the court. Your Worship, I want to say at the beginning, I have said that the prosecution is not a rubber stamp of the police. They must do their job. And it seems as if they are a rubber stamp, as in this particular situation, Your Worship. I have an official receipt of purchase of that weapon, clearly described. And then I have a picture, Your Worship, from taken at the police station, Your Worship. Show the type of weapon with the writing showing it's not a proper weapon. That's why, Your Worship, I'm saying if the investigating officer had done his work, he will have written the serial number of the weapon. He will have described the weapon as the automatic or semi-automatic or an ordinary rifle. He doesn't give the court that information for the court to be able to make a correct decision. weapon, Your Worship, automatic weapon, Your Worship, is a Schedule 5. But they are not telling the court what is the type of weapon. And if they don't say we take it as an ordinary rifle, even if it was the real weapon, Your Worship, it will still not be a Schedule 5 because it's not automatic. And they have not alleged it's an automatic. Your Worship, clearly, the police at Katlehong were not stupid. They were not stupid, Your Worship. The investigating officer cannot describe the police at Katlehong to be stupid, to leave a replica in the table like this, or a live weapon in the table like this. You won't do that. As soon as the police are convinced it's a replica, they are able to put it on the table, take pictures, and they show even those cartridges there, which is not a real ammunition, Your Worship. And the police in their own statement, they don't write in their own charges, they don't write about ammunition. They are charging him of weapon, a rifle, but they don't talk about ammunition. But in their report, they talk about ammunition. Where did this ammunition come from? Your Worship, let me move. I've already displayed. If Your Worship, I would have loved to hand over this. Yes, I'll make a stitch. Your Worship, I'm giving the original receipt. No, we have given the state copies. .10, Your Worship. 5.10, Your Worship. Possession of dangerous weapon, 2 pangas. Your Worship, that's not a Schedule 5. Possession is not a Schedule 5. Malicious damage to property, vehicle belong to maternal family, witness. That's not a Schedule 5, Your Worship. The state has not alleged before court that any of the accused or the applicant has been found guilty on any of these charges. Thus, make it a Schedule 5. They have not done that, Your Worship. Your Worship, I have mentioned that I'll go back to 5.4, contravention of Section 123B of the Firearm Control Act, failure to produce license. If we are talking about the rifle, Your Worship, it does not need a license. So it is not a Schedule 5. It seems as if my learned friend investigator wanted to please the public in keeping the most famous prophet in prison. There is nothing that makes them to keep him in prison. Your Worship, that's not a Schedule 5, and the prosecutor knows that. That is not a Schedule 5. You have a right, my friend, to stop me if I'm moving fast. Okay. That I put our case across, Your Worship.
Worship. Yes. So Your Worship, I don't know if I'm assuming my colleague is saying this copy of a receipt relates to the firearm that was seen in the video. I don't know what this receipt is pertaining to what exactly, because if my colleague says this receipt pertains to the firearm that was seen in the video, which was in the possession of accused number 2, then how can we actually determine that this relates to that firearm? Because that firearm has a serial number, Yoshi. That if he calls it a replica, whatever it is, it has a serial number. And this receipt does not display any serial number which links this receipt to that firearm. Now, in the state's view, this receipt proves nothing. This could be a receipt for any other gun held by any other, or rather any other, it's written here, blank gun. This could be a receipt for any other blank gun which is held by any other person and which could not have been, or which might not have been this, the blank, supposedly, as my colleague says, it's a blank gun, which was held by applicant number 2. So this proves nothing. This proves absolutely nothing. And furthermore, Your Worship, the state's view, the evidence, I don't know whether my colleague remembers very well that when I was reading the affidavit by the state in opposition to bail, we mentioned that there were two rifles at the scene. There were 2 rifles. This is a slip. This is well, I don't know what it is. So I'll call it a receipt. It's a receipt for 1 rifle, 1 blank gun. It does not specify which gun exactly. And whereas the state did mention in its evidence during the bail application that there were 2 guns at the scene. At one point, applicant number 1 opened the boot of his vehicle and he took out what appears to have been a rifle and he fired shots with it. Now, if maybe my colleague wishes to prove that both guns were not real, then come with both receipts, and both receipts ought to have some serial number indicates that this is a receipt in relation to this firearm. That doesn't show in this paper that's before me. And this picture, I don't know. Okay, fine. I don't know what gun is this. My colleague says it comes from the police station. Maybe it's Your Worship's prerogative, Your Worship, to accept evidence, whichever evidence Your Worship during bail applications. But the state is of the view that this doesn't show which firearm is this. I have no clue, Your Worship. And furthermore, we've not been provided with these affidavits that are now being disentangled and submitted piecemeal to the court as exhibits. We are before court today, Your Worship, as the state, after been requesting the defense's affidavit, or rather the applicant's affidavit, several times to no avail, so that same can be properly perused by the defense, by the state, to determine whether indeed there are new facts to justify the accused person to be released on bail. But we haven't yet received such an affidavit, Your Worship. And we come before this court today under the pretext by my colleague that they will be bringing bail on new facts. But now they saying they're bringing a technical point first before bail. The state is of the view that this is just another way of bringing not new facts into consideration by the court in deciding whether the accused person ought to be released on bail or new facts. This, if they've had this, and I heard my colleague saying, the fact that it is not a real gun that in itself is a new fact. But, Your Worship, this let's assume then, okay, fine, it was not a real gun. That's a fact that was available to them. It was available to them. That fact was not used in their first bail application. That fact could have been used in the first bail application to indicate that the state does not have a strong case with regards to the fourth count, indicate that they have the accused persons have been found with a rifle, a real rifle. They didn't. That was available. So to use that, an available fact, as in a bail on new facts application, and not say no, we're using this as part of the new facts. No, but then we're using this or as or on the basis of a technical issue first before we delve into the bail in new facts. That's disguising what they're actually trying to do, Your Worship, and the state is strongly opposed to the manner in which the defense is going about this proceedings, Your Worship. In the state's view, they were confusing proceedings. It became just a confusion, but Your Worship did clarify that it's a point in limine, and the state will accept Your Worship's clarification. But having said that, Your Worship, we still maintain that this receipt says nothing. This picture says nothing. This receipt, ordinarily, if it ought to have, because the gun, be it a blank gun, a replica, has a serial number, and the receipt in relation to that purchase ought to have a serial number indicating to which purchase does that receipt relate to. This is nothing, Your Worship. And therefore, Your Worship, the state is of the view that it is a Schedule 5 offense. There's 2 rifles. My colleague has been arguing on and on about 1 rifle, which he submits that what he gave to this court is proof that it wasn't actually a rifle, but a replica. But the state submits that there's 2, and the other one is still was not given by the first applicant. The other one is still in the not in possession, physical possession of the first applicant, but he knows where it is. And the state is of the view that which we saw on video, which was fired in public, is a rifle use. And therefore, the Schedule 4, or rather I believe it's the 4th count. The 4th count makes this matter to be a Schedule 5, in that the state has seen in the videos that accused person was firing a rifle, and furthermore, this does not prove that what the accused person had on the day was not a rifle. This proves nothing. This shows whatever. I don't know what it proves. It's just a receipt. So, Your Worship, I don't know. Are we still gonna go to? But we leave it in the court's hands, Your Worship, seeing that my colleague was addressing a point in limine for your worship to come to a judicial decision in this regard. As a recusal.
Thank you, Worship. The state has not addressed the issue. Let me say all the issues. They just stick to a rifle, Your Worship. I have argued, Your Worship, that even if it was a rifle, they have not alleged it was an automatic rifle, right? That's number one. Let's say they talk about it is not a replica, Your Worship. They suppose the state supposed to have given a serial number of that rifle. Your Worship, every weapon, a firearm, not talking about replica, Your Worship, every firearm has serial number. I have said, Your Worship, the state has failed. They have failed to put in their affidavit the serial number. If serial number have been interfered with, rubbed off, the state must say the serial number has been rubbed off and thus the weapon is sent for ballistics. Here they give us a reference of ballistic. Using the same argument, any gun that they would have taken for ballistic would be the same situation. Here, Your Worship, there is nothing in law that says a replica must have serial number. He has not shown that. A replica is a replica. It's not a real gun. That's why on it, Your Worship, you'll see on that picture there are white things that are written there, which is warn that is not a real gun. A military man like myself, Your Worship, will see it that this is not a real gun. Now the danger of it, Your Worship, of that, it is a danger to the carrier. The hold of that gun is a danger because if I'm not aware it's not a real gun, I may shoot him. So the danger is not on the public, it's on the same person who's holding that weapon. Now he comes in, he argues to say, no, they are two rifles. There is no evidence before this court to show that really there is the second rifle. It's just a hearsay misleading the court. In fact, this prosecution, Your Worship, not once has misled this court. They have come to court and say, when we say these are the third accused is the parent of the two children, the holder of the rights. And they said, no, we've got a temporary or court order, interim court order that granted their granny a right to the children, which is not true, Your Worship. So if they are so much damned to mislead the court, I'm sorry, Your Worship, they are the officers of this court. They're supposed to tell this court nothing else but the truth. They must assist this court to come to the correct conclusion, not what they want. Your Worship, when they talk about second rifle, it's very interesting. The applicant were at the police station. All the tools that they found, the weapons they found them at the police station. Now, where does the second rifle come from? If he talks about a video He should have shown us the video that there is really a second a rifle. Now they come up and speculate, say there is a second rifle. It's an embarrassment to both the police and prosecution, who is allowed to be used as a rubber stamp of the police. It's an embarrassment, Your Worship. Here I was expecting my learned friend to say, yes, a rifle is a Schedule 5, and then he support his statement. Where does he get that a rifle is a Schedule 5? If the rifle is being used in robbery, yes, Your Worship. If the rifle is used in murder, yes, Your Worship. But not just a rifle and then you say it's a Schedule 5. I have put it, Your Worship, to say this is a replica. But again, Your Worship, I've argued in terms of the real rifle is not a Schedule 5. And they have not contested my argument, Your Worship. As we stand now, they have not contradicted whatever I've said is not a Schedule 5. Your Worship, we will leave it to court to make its own decision. Thank you.
Reserve. Okay, we can swear in your ship and lead evidence.
At least a certificate kgotsa tokomane e netefatsang gore melato e tlosanelo ka Schedule 5. Schedule 5 e tlhalosa gore ba mosebetsi wa lona jaaka batlosiwa o bontsha gore tsamaiso ya toka e dumela jwang tokolo ya yona le gape wa tlhalosa gore ka lebaka la gore ga ba tlisa ditokomane tse e bontshang gore melato e tlosang yona ke ya Schedule 5 di go tla tshwanela go iqhosa kgotsa go lesekisa melato ena ka tlasa Schedule 5 go palo go tla le fetile Schedule 5 le tse Schedule 1. Schedule 1 se tlhalosa gore tla ba mosebetsi wa mosekisi fana ka mabaka a bontshang go baneng le go tla le sa tshwanela go dumela toko ya lona ya pedi le gape a ba tswela pele gore lona jaaka baqhosiwa di na ditokelo tse di tshireletsang tse tlasa molaotheo le gape ba tlhalosa gore go tloga boqalo ga ba nke ba dumela gore melato ena ke ya Schedule 5 le gape wa tlhalosa gore ya ba ne ba hloleha go bontsha ka bopaki gore melato ena se ya Schedule 5 ba tla tswela pele ka kopo ya rona ya go lekola ka pele mabapi a dintlha tse dintšha le gape wa tlhalosa gore o kgatlanong le gore mosekisi molato ona o busetse morago empa o bona go le botoka gore mosekisi ena a tlise mopaki a tla kena bona mo lekgotleng a tlhalose ka botlalo gore molato ona e ba Schedule 5 ka mabaka a feng kgotsa ka bopaki bo feng a ba tswela pele mabapi a dikulo le sethunya ba tlhalosa gore e ka se nne Schedule 5 gobane a gona ballistic report ke pedi e hlaya ho bane ba sebetsang ka ho hlahloba ba dithunya e leng ya hlalosa hore sethunya se fumaneng kgotsa dithunya ke tsa mofuta ofe le hape wa hlalosa hore mosekisi mabapi a melate ba qosang yona ga ke ba bua nnete haholo hampe ka taba ya kidnapping le hape o la hlalosa hore mosekisi o la bua maka a bua a re gona le lekwalo le di lantshwang ke lekgotla le le ngafang kgono wa bana tokelo ya gore a hlokomele bana le hape wa hlalosa gore mabapi a taba ya J50 a se nnete hobane lona jaaka ba qosuwa le fumane le le police station ditjhankaneng le hape wa hlalosa gore ba tshwanetse ba bitse mopaki o tlo hlalosa gore melato yona e ba schedule 5 jwang le hape wa hlalosa gore hobaneng ntse ba tswela pele ba bua ka melato e qosang yona ya ho tshwara dikulo hobaneng hala qosa yona melato eo le hape wa hlalosa gore melato e meng e le qosang yona e kgatlanong le ditokelo tsa lona a ba kena ka botlalo mabapi a melato e qosang yona a re la ntlha molato wa ntlha wa tshwara sethunya se se tlasa molao o tshwere yena receipt kgotsa tokomane e bontshang gore sethunya seo kgotsa rifle AK47 ile ya rekwa ko 290 China Mall Amakamko Johannesburg e le lebitso la lebetlele leo le hape ba hlalosa gore melato e mebedi le qosang yona ya ho kidnapa kgotsa ya ho petela ya bana ba babedi e ka se be schedule 5 hobane ile wa hlalosa gore moqosi wa boraro ke yena ntate wa bana o na le tokelo ya ho tlhokomela bana ke ka ho moatlhodi o la monokolla kgotsa a dumela kopo ya hae ya ho lokolla ka pedi le hape wa hlalosa gore molato wa ho tshosetsa e ka se be schedule 5 ha baneng ha sokwa wa tliswa bopaki bo bontshang gore motho la fumana a na le molato mabapi le molato o tshwanang le o le hape molato wa trespassing kgotsa ho kena pihing kgotsa tipeng ya motho sena tokelo ka se be schedule 5 hobane lefelo leo mo le ketsahalo e etsala teng ke lefelo le dumeletseng mongwe le mongwe wa setjhaba jwale ka se be trespassing le hape wa hlalosa hore molato o mong o wa tshwara sethunya gantle le tokomane kgotsa license e ka se schedule 5 hobane rifle a tlhoke gore motho a be le license gore a itshware le hape rifle eo le se rifle ya mannete ne le sethunya se tshwanang le rifle le hape wa hlalosa gore o sebetsa jaaka modisi o sena ditokomane le yona molato ba o qosang ona ka se schedule 5 o thunya ha se thunya mo pela ga setjhaba le yona ka se schedule 5 molato wa hlasetsa e lebedi le qosang yona le yona ka se schedule 5 le hape o supa motho ka sethunya ka se schedule 5 hobane no sena sethunya se leng sa bontsha gore motho la supa ka sethunya le hape wa hlalosa gore molato le qasang ona wa ho tshwara sethunya ho sena license e leng rifle nka se be schedule 5 hobane o tlise tokomane kgotsa receipt e bontshang gore rifle eo ne se rifle ya mannete le hape molato le qasang ona wa ho tshwara dipulo nka se schedule 5 hobane tokomane ya tlisitseng e bontshitse gore sethunya seo a se sa mannete le dikulo tsa tsona a se tsa mannete le hape wa hlalosa gore o tlile ka senepe se hlahang mane police station se bontshang gore sethunya seo ne se sa mannete le hape ne se sena serial number e bontshang gore ke sethunya sa mannete le hape le molato mong o qosang ona wa ho thuba thipa kgotsa malicious injury to property le yona nka se be schedule 5 le hape le ponisa le etsang dipatlisiso le batla ho senya lebitso hobane wona o le moruti yo tsebehang le hape a o senya lebitso ka gore o dule ditjhankaneng a o kenetse mahlo a batho a ba tsela pele a hlalosa ka boqetelong gore sethunya se se buang ka sona sa bobedi se ko kae le hape ke ka lebaka le etsang gore se sa fumana ko police station ke eng le hape video e mosekisi a buang ka yona ke ko kae hobane e sa tliswa jaaka bopaki mona le hape wa hlalosa gore sethunya seo ha eba ne se sebediswa ho tshwara poho kgotsa bolaya motho mong ana tla hlalohanya hobane molatona ba o qosa ona e ba schedule 5 ke sene se bua ke moeledi wa lona seo ke tla kena ko sene se bua ke mosekisi la ntlha o la qala gore a hlalosa gore moeledi wa lona o senyatsa nako ka ditlhatsa di buang go bana ba ka le kopantshang ka jeno ke gore re tlo mamela kopo ya lona ya lokola ka pedi le hape wa hlalosa gore dintlha tsena tsohle ke o senya nako le go tshwarella le hape wa hlalosa gore dintlha tsena ne ba tshwanetse be ba di buile ha ne dipuisano tsena di qala gore ba kgatlanong le schedule gore a se schedule 5 le hape wa hlalosa gore ba ile ba dumela gore ke schedule 5 o fitlela ba tle ba fetse le kopo ya lona ya ntlha ya lekola ka pele o fitlela ebe e hanetswa le hape le baka le re kopantshang ke gore moeledi wa lona a tlise dintlha tse dintšha tse tla kgotsofatsang lekgotla gore go baneng ba tshwanetse ba dumele gore le lekolo ka pele a ba tswela pele gore ha baneng ka nnete ba batla tokomane e bontshang gore molato ona kwa schedule 5 o tla kopa molato o khutlisetswa morao gore a kgone ho buisana le baeteledi pele ba hae kgotsa basekisi ba baholo ba kgone ho mo thusa ka tokomane e tla bontshang gore molato ona ka nnete ke wa schedule 5 le hape wa hlalosa gore dintlha tsohle tse ba di buileng ke moeledi wa lona se dintlha tse dintšha le hape wa hlalosa gore ha baneng ba ntse ba netefatsa gore ba batla certificate se bontshang gore ke schedule 5 ba tla kopa gore molato o busetswe morao le hape ka se tsebe gore o tla hloka nako e kakanang ba hlalosa gore la bofelo gore resiti ba itlisitseng ha ba tsebe gore ke a sethunya sefe le hape wa hlalosa gore sethunya sile sa bontsha gore sina le serial number le hape ke sethunya se ba se fumaneng ko moqosuweng wa bobedi le hape wa hlalosa gore go na le molato go na le sethunya se seng se senyamaletseng se go sa tsebeng gore se ko kae le hape wa hlalosa gore resiti eo a e netefatse gore e bua ka sethunya sefeng ka nna resiti ya sethunya sefeng le sefeng le hape wa hlalosa gore resiti eo e bontsha fela mabapi a sethunya se se lotsi empa ona le dithunya tse pedi go lefelong la ketsahalo eo le hape la hlalosa gore resiti eo a specify kgotsa e netefatse gore e bua ka sethunya sefeng mo molatong ona le hape moeledi wa lona o ntse a tswela pele a bala di-affidavit kgotsa maikwalo a boikanyo e ya bona ba senang bona le hape a ba fumana monyetla wa bala makolo ao o netefatsa gore dintlha tse di tlisitseng ke dintlha tse dintšha mabapi a kopo ya lona ya lekola ka pele le hape e ka se ne ntlha e ntšha gobane di gale ne ba tseba gore sethunya seo ga se sa nnete go tloa dipuisano tsena be di qala a se ntlha e ba simolotseng o e fumana ka jeno le hape wa hlalosa gore ha dumelane kgotsa o kgatlanong le mokgwa o moeledi wa lona o sebetsang ka ona kgotsa o etsang dintho ka ona le gape wa hlalosa ka botlalo gore resiti le tlisitseng ha e tlise bopaki ba se ke se ne se bua ke moeledi le mosekisi wa lona le tlhalwantse understood.
After your worship, my shield is first with MMAISIDA. Signing is Swipe spells with NGWEPA. Thank you, worship. I'll conduct my testimony in English, worship. No objection, worship. So help me God.
Thank you.
Sit down.
Sir, where are you employed?
In the SAPS.
How long have you been employed?
22 years. 22 years service, worship.
What's your rank?
I'm currently a captain in the police, worship.
Which division or station or department?
I'm based at SAPS district, Ekurhuleni.
And then this the case relating to applicant 1 and applicant 2, the criminal case, are you aware of it?
I am, your worship.
How are you aware and involved in it?
The matter was allocated to me immediately after the incident, your worship, to investigate.
So you're the investigating officer?
I am, Your Worship.
Are investigations finalized?
Not yet, Your Worship. We're still waiting for the video in question, Your Worship, that was downloaded at the school. We sent it to cybercrime for them to do analysis for us. And the SAP-69 as well is outstanding.
So, as an investigating officer, you are aware of what transpired on the 5th of August 2024 in relation to accused number 1, 2, and there was a third accused, well, applicant 1 and 2 today. How many videos do you have during this investigation?
It's one video, Your Worship, that was downloaded from the school CCTV footage.
And then in that video, can you just briefly tell us did you have sight of the video?
Yes, I did immediately after the first appearance of both accused before this honorable court.
And then what did you observe when you had sight of the video?
Yeah, I went to school after the appearance, and I've viewed the footage there in the presence of the headmaster of the school. What I've seen there, it's from the gate, Your Worship, there was a black BMW and a white vehicle and the other vehicle across the road. And I saw accused number 1 and number 2 before this honorable court coming in. Accused number 1 was having 2 pangas and number 2 was in possession of the rifle in question, Your Worship. And there was a fight inside the school staff rooms there, where accused number 3 was locked in the butler door that goes through the passage. But finally, when accused number 1 was fighting there, he managed to give accused number 3 a panga to open the forced entry, to open the door. And they managed to come out, and he was like paving people who were in front of him with the panga. And when they leave the gate, there were people who were passing by who were actually disturbing him to get into his BMW. And the accused number 2 was in possession of the rifle. And accused number 1 went into his BMW vehicle. He came back with another rifle and he fired 1 shot. That's why he dispersed the crowd. And they managed to get into this BMW and the other one into that other vehicle. It was the driver of that vehicle and the guy who was carrying the 2 kids with.
And then in your investigation, I see that you mentioned several weapons. Were there any weapons recovered during the investigation and so forth?
Not. It's only the rifle and the 2 pangas that were not recovered but handed to the police. But this other rifle that was used to fire a shot was not recovered.
And then, so how do you know from your investigation and what's seen in the video, how do you know which rifle is which? Seen that there's 2 rifles, and you mentioned that the other one was in the boot and the other one was carried. Well, I didn't. Was carried by the second applicant. How do you know which one is which?
I cannot tell as to whether the one-handed is the one that was used by accused number 1 or is the one that was in possession of accused number 2. That I cannot tell.
And then as a police officer, do you have any form of experience relating to firearms and so forth?
That is why I took it to ballistic, because I knew I'm not a ballistic expert. But what I can tell you is a replica is an imitation of certain firearm, and a replica is not a toy. And what you are talking about there, it has, a replica cannot have, a toy cannot have the so-called trigger. A toy cannot have a barrel. But I don't want to go in details into that. I think it's wise enough maybe for the court to invite a ballistic expert to come and give. But the little I know is a replica is not a toy. That is why it has a barrel, it has a trigger that you can pull and it will discharge.
So you say the accused person, accused number 2, or rather the first applicant, sorry. The first applicant in the video was firing shots with what would appear as handgun or rifle, or what type of gun in your view?
It's a rifle. It looks exactly like the one that was handed into the police.
And from what you see, would you say well, maybe you can't tell, but in your view, would you say was it a replica or a real gun or what?
The one that was in position of accused number 1.
No, I'm saying yes, the one that was used to fire shots.
Look, even this one that you're talking about now, if you see it, or if one point you with, or if you see somebody carrying that, you cannot say this is a replica. That is why people are all over the place. So even that one, I cannot tell as to whether it's a replica or it's a real firearm up until recovered and tested.
So far, the other firearm, it hasn't been recovered?
It's only this rifle that we're talking about, and other firearm was not recovered.
And the one that you have, in relation to ballistic reports and so forth, investigations finalized in that regard?
Yeah, it is. We're in possession of the report.
Okay. And then does it have a serial number?
It does.
And is it a real gun or replica?
You know, let's read that report if the court permits.
No, but it must be news, sir. Or you're not into...
I don't. This real gun, like I said to you, replica is not a toy.
Yeah.
So if you're saying to me, is it a
Okay,
real
no,
gun?
yes,
I
yes.
have a problem with that one.
Okay. So is it a replica or is it a... what sort of gun is it?
That's what I'm saying. If the court permits, let's just read that one line that identify the fire.
Okay. You mentioned you mean the 2 and 2 still?
Yes, I am.
Bishop, with the permission of the court.
We have no objection, Your Worship. We have to object this.
No objection, Your Worship.
Can I, with your permission, Your Worship? Okay, it's point 3.1. I'll start where they are talking specifically about the firearm, Your Worship. It says it's 9mm PAK caliber. I can't read this English. It says the Clio model AK9 fully automatic blank rifle, blank firing assault rifle with serial number so. I'm not sure if. Let me repeat it, Your Worship. It says 9mm PAK caliber, the Clio model AK9 fully automatic blank firing assault rifle with the following serial numbers.
So, sir, in your view, if a person uses that the rifle that you managed to secure into his position, they use it at a person, can it cause damage?
Yeah, if it's at close range, definitely it will cause a damage.
Would that damage be fatal?
Yeah, I mean it sparks the fire. If it can damage your eyes. Let me give you an example. You can be blind if it's fired very close to your face.
And you say the other one, you're not sure, you don't know where it is, and it hasn't been located, correct?
Correct.
Okay, is there anything further that you think we should address to the court regarding the specific issue that's of one of contention?
Yeah, I want to say before this honorable court that the vehicle used when I arrived at Katlehong North Police Station, they were all not there. All the vehicle that was used in the commission of the crime, they were all not there. And I interviewed witnesses, and there are witnesses who were like pointed with a pistol, not a rifle, by accused number one. And when I checked with firearm registry, with accused number one's ID, I've established that he's owning 2 licensed firearms. So that's all what I wanted to put before this honorable court.
ke sene se bua ke bopaki bo ntate wa hlalosa gore o sebetsa ko SAPS o na le jara tse 22 a sebetsa jaaka captain o sebetsa ko SAPS ya ko Ekhulele la plola botsa go wa tseba ka molato ene o le khosa ngwana ba wa tseba hape ke na etsa le patlisiso le hape di patlisiso di so felle ba ne sentse na shota ka video ya mane ko sekolong le SAP 69 ke le kwalo le hlang sepoliseng le hlalosang gore ana lona jaaka ba qosuwa le na le melato ya gale kgotsa dikatlholo tsa gale pele go tlala molao le hape wa hlalosa go wa tseba ke tsa halo le ya itsa ka di 5 tsa August 2024 na ba pega molato o qosa ngwana jaaka lona ba qosuwa ba bararo le hape wa hlalosa gore o la botswa ka di video ba hlalosana le video e notsi e ya ntsaetsa dipatlisiso ka yona e ya tshwanetseng a inka mane sekolong mo petsahalo e le ya etsala teng pele a pele a botsa gore video e bonene ba hlalosa gore e bone pela ga morao a gore bona ba qhosiwa le hlaile hlantlha mo pela lekgotla la wa hlalosa gore ile ya mane sekolong a le sheba le principal wa ko sekolong le hape se a se bone gore mo hekeng ona le koloi tse pedi BMW e2 le koloi e nngwe e sweu le hape o bone moqosuwa wa ntlha le wa bobedi ba kena le hape moqosuwa wa ntlha ana tshwere diphanga tse pedi moqosuwa mobedi a tshwere rifle le hape wa hlalosa ona le ntwa ka mogare ga sekolo mole moqosuwa boraro yena o ile ngalokollwa ba mo kwalletse morao ha patla ke mo he moqosuwa wa ntlha a fa moqosuwa boraro phanga gore a robe batla a gone go tswa le hape ba ile ba tswa le hape moqosuwa wa ntlha o nentse a le tlisa phanga a thusa batho go ba buletsela ke ka mo he morawa mo moqosuwa wa ntlha a ya koloing ya hae BMW a tswa ka rifle a thunya hanotsi udimo gore batho ba phatlalle gore ba gone ba go bulela tsela ba ba le la poa hlalosa gore mo di weapons tse ile nda fumana mo bating a molatona ba ile ba fumana rifle e notsi le diphanga tse pedi ke tsona fela tse ne ba di fumana la pola hlalosa gore a kgono a rwantsha gore ke rifle e feng e leng ya sebediswa ko ketsahalong eo lapo wa hlalosa gore yena ka lepodisa o le wa nka sethunya se ileng sa fumana gore ba lo se etsa ballistic report ke e etswang ke batho ba sebetsang ka hlahloba dithunya le hapa ba hlalosa gore sethunya se replica a se toy kgotsa se sethunya sa bapala le hape wa hlalosa gore sethunya sa bapala kgotsa replica enena le haina barele kgotsa mo kulong e kena teng kgotsa trailer mo sebedisa mothunya sethunya teng le hape wa hlalosa gore sethunya se a se boneng ko videong hana bonnete ba gore ke sona se tshwereng ke maponisa kgotsa se sona le hape wa hlalosa gore sethunya se seng sa bobedi se leng sa sebediswa ba se fumana le hape ba ile ba etsa dipatlisiso ba fumana gore sethunya seo se na le serial number a wa tswela pele a bala report mabapi a sethunya seo a se hlalosa gore ke sa mofuta o jwang le hape mosekisa ba mo botsa gore sethunya se ba se fumaneng anna se ka lematsa motho ba hlalosa gore e se ka mo lematsa ha baneng o haufi le motho ya sethunya le hape o ka etsala gore motho a lahlehelwe ke o bona kgotsa a be sefofu ha baneng ba sethunya pela mahlo a hae a le gaufi le gapa ba hlalosa gore mabapi a dilo tse ba sa mbotsang tsona a hlalosa gore dikoloi tse pedi e ntshuleseo ene siyo ko Katlehong police station ha ena a ne a fihla le hape ba hlalosa gore bona le bapaki ba bang ba ile ba bona ketsahalo ba le batho ba ne ba supa ka sethunya ke moqosuwa wa ntlha le hape ha dira dipatlisiso ile a fumana gore moqosuwa wa ntlha bona le dithunya tse pedi tse tlasa molao ke sene se bua ke bopalesa.
Thank you. Your Worship, I have not been handed the report, which is now before court. Whether the witness used one line of that report, it's before court now. We're entitled to a copy of that report now, not tomorrow, but now. And I've not yet been provided with that copy. I have said, if you dispute the schedule, and if anybody comes there and witness at the state peril, because we will now get the opportunity to cross-examine. You have told this court that you visited the school. When was that? Date, time?
I can, through you, Your Worship, if I can be given a docket, then I can refer with dates there and time, Your Worship. Your Worship, the date was the 16th of the 8th month, 2024.
16th August. What time, sir?
I cannot be exact, Your Worship, with the time, but that I can tell it's the date, Your Worship.
Was it in the morning or in the afternoon?
Your Worship, I didn't look at my time, but it was in the afternoon.
Were you accompanied by any other person or you were alone?
I was alone here, Your Worship.
You told this court that you are from the regional office. Where is that office situated?
Your Worship, it's not regional office, it's a district office.
District office,
It's
yes.
situated in Clorcop. It's just between Kempton Park and Tembisa, Your Worship.
Cloroko.
Oh, my apology. My apology, Your Worship. Yeah, I was just answering the question, where am I based? I was saying I'm at the district office, Your Worship. It's in Clorcop, just between Tembisa and Kempton Park.
Do you know when this incident happened?
Yes, Your Worship.
Can you give us the date?
It was on the 5th, Your Worship, of the 8th month this year, Your Worship.
You say you were given a video by who?
Your Worship, I was never given a video. I've viewed the video and thereafter I've called the expert to come and download it.
Where, exactly where you viewed that video?
Right in the headmaster's office, Your Worship.
What did you see in that video?
Like I said, Your Worship, the most interesting part is when they leave the crime scene. There were people who were passing by that blocked the accused number one. No, let me not say accused number one. It was a black BMW. I don't know whose vehicle is that. There were people who were blocking accused number one to get into his vehicle. That's when he went in, opened the door, pulled another rifle. When accused number two was still seen carrying the other rifle, he fired one shot, he dispersed people, he got into the vehicle and they drove off.
So the people were blocking the applicants from entering their vehicle.
Correct, yes.
Did you see anything inside the school on that video? What transpired?
Which side of the school, if I ask?
In the video, it shows you whatever it is.
Correct.
I'm saying inside the school.
Correct.
Wherever
Correct.
part of that.
People were just flying all over the schoolyard and inside between passage inside the school building, Your Worship.
There was no fight inside.
There was.
Right? Tell the court. Tell the court.
I have explained that, Your Worship, to say accused number 3 was locked inside. It's a butler door in the passage. That in front of that door, there was chaos. It was fight. They were like, waving each other with pangas and rifles. And that's when he handed in the other panga for accused number 3 to forcefully open that door. And when they leave, there was like fight as well. But because they were in position of the rifle and pangas and they were armed, and other people were not armed, they managed to escape that situation. That's when he arrived at the gate, already there were people who blocked his vehicle. And he went inside, Your Worship, in that vehicle. That's where he pulled a vehicle. He fired one shot, managed to disperse people, and they got into different vehicles and they followed each other.
Accused number 3 locked inside.
Correct.
Did you inquire why was he locked inside?
The reason for him to be locked there, I spoke to Deputy Principal, Your Worship. He was saying he couldn't understand why one can force to take keys that belongs to him. Then he said to him, look, let's go inside, let me call the police and other family members to verify if surely indeed you are eligible to have these kids with you.
As a policeman, a seasoned policeman with 22 years of service, locking of a parent behind the butler, was it lawful?
Your Worship, there's no crime with that. The deputy principal never committed any crime. It was just to say, look, wait, let me understand your story. Why are you two guys fighting over the kids? And you should call the police and see how can we best sort out this issue. So there was no crime.
I have not talked about crime. I've said, is it lawful?
It's not unlawful.
It's not unlawful. Oh. Thank you, Your Worship. Yes, thank you, Your Worship. You have testified in this court to say that you have a report. Have you received this report? Your Worship, I just want to place it. I have not received the report. You said the report says that the rifle is a fire blank. Is that correct?
It's correct, Your Worship, but I wanted to say to you, the author of that document, if you want to go further and explain what is this, what is that.
No, I'm not interested in the author. I'm interested in what you are telling this court.
You are correct.
You are saying the rifle fire blanks.
According to the report, you are correct, Your Worship.
Does it require a license?
You should call the expert to come and explain that part. Your
Thank you.
It's not my line.
Thank you. No. Don't even go there. Don't even go there. You have talked about the second rifle that is still missing. Can we have that video to see that indeed there is such a rifle?
Correct, Your Worship. If given time, that will be available.
Is that rifle identical to the one you have now?
I don't understand the question, Your Worship.
I'm asking a simple question. Is the rifle that you're saying you are still looking for it identical to the one that you have now, that you have a report on?
I cannot say, Your Worship. I cannot be able to answer that question, Your Worship.
What color was the vehicle where you say the accused went to?
It looks black on the footage here, Your Worship.
It looks back. What will you say if I tell you there was no black car in that area?
That's your view.
Thank you. You have told this court that firing a blank at close range, it can blind a person.
Correct.
How did you come to the conclusion that a blank firing weapon, or as you say it, is a Schedule 5?
Your Worship, he like this word blank. A replica, Your Worship, is not a toy.
What is it?
It's an imitation of a firearm.
Imitation
It's an imitation.
of a firearm.
You took this thing and make something that looks like this, exactly like this one, with parts on it that some are original, some are not original.
Is it a firearm?
It is.
Your Worship, I have no further question. The witness is contradicting himself. One time he says it's a imitation. Then he says it's a firearm. Imitation cannot be what it's supposed to be.
Thank you, Your Worship. I have a few questions. I will not be long. I'll be very short, very short. Already, Advocate Dlamini has asked some questions that were important. I just want clarity, Mr. Ngwepe, to clarify a few things. Mr. Ngwepe, you said you saw everything on a CCTV, right?
Correct, Your Worship.
What was the quality of the CCTV? Because the quality of the CCTV normally is not of high resolution.
It's clear, it's very clear. I'm not sure whether should I use the words the quality was good or what, but it's clear. You can see.
You said when you were answering the issue of a BMW, you said it's a black. It looks like a black car. Does that mean that the video was not clear to say it's a black car, to say it looks like?
You know, in a video, sometimes something gray can look black. That's what I'm saying. It looks like a black.
So you are agreeing that the CCTV was not clear?
It is clear.
It is clear, but it looks like, so it means it's not clear.
Let me reiterate that question. It's a black BMW.
So if you are not able to tell who owned the BMW or the registration of the BMW being so big, how will you be able to tell if the gun on the video is a replica or is not?
Look, the registration number on the vehicle, on the footage itself, does not, actually the footage does not reflect the registration number, and I could not, I didn't find the vehicle on arrival. If I should, I will be saying before this honorable court, the vehicle belongs to, and the color is the make and model of the vehicle.
Okay, let's talk about the replica. You said the replica can blindfold a person if he's shot on a close range.
Correct.
But do you know that the reason is called a replica or a blank gun is because it does not release the projectile of a bullet. It only makes a sound.
This one, before court releases whatever you're talking about.
It is not true. You are misleading the court when you say a replica gun can release a fire or anything. A replica gun, its barrel is closed. The only thing that it does is to release a sound. It does not even need an expert to know what is the meaning of a blank gun. If then it can release a bullet or a fire, it's no longer a blank gun. It should be something else.
Your Worship, I don't agree, Your Worship.
You, okay. Now, when you say you are not able to tell the difference if it's a replica or not, but yet you are able to tell what impact it can give, how much of knowledge do you have with the gun to say you are able to tell what's the impact of the replica gun, but yet you are not able to tell if it is real or not real?
You know, there was big smoke after he pulled the trigger there. That is a sign that it releases something on it. It's not close as you are saying.
Okay, let me put it to you, Mr. Ngwepe, that there was only one gun which was handed over to the police station, which you are in possession of, and which is a replica, that we have submitted its purchase receipt. And equally so, this replica gun, it is written on it that this is not an actual gun. So the video you are talking about, if really there is a video, you should have brought it here. A video should not be described, it must be seen. There is a TV there that it could be played, and we see that video, and we are able to mark perhaps the gun that you are talking about and the gun that you have, and maybe look at the similarities. But so far, you cannot deprive a freedom of a person on described video that you do not produce in court. Thank you, Your Worship.
Can I? Yes, Your Worship. Your Worship, we have the footage. So, you know, it cannot be that we don't have it now, that we don't have the footage. We have footage that definitely depict what I'm talking about.
That's it. What is on me? This is
It must be kept in the. This is not a trial. It must be kept in the docket. Yes. So I will hand it in onto the record once the defense has a copy. Do you have a copy, Mr. Dlamini?
No, I don't have.
Okay. All right. Time is 4 o'clock. To adjourn for tomorrow. Oh, I'm not sure.
As the court places.
tomorrow should come.
Where are you tomorrow, Mr. Villarreal?
And how do you have it?
Yeah, you've got colleagues. They'll go. Miss Mudamsho will go to district court number 1. That's finalized.
They postponed, and she indicated that she will not be doing any trials in my court.
See, I don't want to get involved in state issues now. So, what was your application now?
What?
What's your application? You're saying...
Yes, the state requests that the matter not be postponed tomorrow. Your Worship. The only time, even today, I had to postpone trials. So the only time I'll not be having trials is the 20th or the 23rd.
No. No, Mr. Vegazi. Your colleagues must come and assist you with your court. Let us get on with the business of the day. I think you're aware that I'm no longer in the criminal section. So I don't know. You need to arrange and find out and see what needs to be done.
Yes, the witness wishes to say something.
Yes, Mr. Mwape? No, but you're done, remember? You're done. Please stand down. Your testimony is done. We just need to finish the copy of the said ballistic report. So, Mr. Mwape, I'm going to excuse you. You're done with the testimony. Unless...
Nevertheless, tomorrow I'm not available, and Friday.
Tomorrow's what? It's Thursday?
Yes.
Slamini?
Your Worship, that's not proper. I have said it and I continue saying it. The state is playing games with the life of the accused. Your Worship, tomorrow is the day the court has decided tomorrow, so will be. I will postpone my cases in other court for tomorrow and or ask my colleagues to go to deal with those cases. This court has listened to this and this court has decided tomorrow. Your Worship, they brought 3 prosecutors for recusal. Now they are telling us they can't swap. It's not proper, Your Worship. That creates a problem. That interferes with the constitutional right of the accused. They first started by saying we should go deal with the new facts. When we're raising a point of law, Your Worship, and up to now, they have not shown what is required to be shown before this court. We are not going to play the game, Your Worship, continue playing this game. It is defeating the ends of justice. Thank you, Your Worship.
I really believe that if the court can do its court role in another section of this building and come and attend to this matter, if the defense can sort out the logistical issues of postponing other cases in other courts, then surely the state in this building can assist Mr. Vilakazi. Mr. Vilakazi, you've got numerous colleagues. I don't even want to mention them. They are in this building. They can assist you in your court of District Court number 1. I really want to finalize this case. I want to. We need to get progress. You had time from last week, the 2nd of September. Today is the 11th of September. And I want to also reiterate that your senior, Mr. Ramavuya, expressly stated on Monday that whatever happens to the recusal application, this matter will proceed. So let us proceed. We have started proceeding. So please get the assistance from your colleagues to come to assist you more so. You are you are faced with this matter, you are seized with this matter. So let's see. I want to help you, I want to assist the defense, I want to assist you as well.
Yes, so she can understand.
Yes.
But not tomorrow.
Let's see what happens tomorrow.
Not tomorrow.
Gentlemen, please stand. Your case is rolled over to tomorrow, the 12th of September. Applicant 1 and 2 remain in custody. You will see then what happens tomorrow. The state must then get their house in order tomorrow, 12th September. Thank you.
As the court blesses.
Tomorrow, before we proceed with this case, Mr. Bonyani, you will summarize the remaining part. Hold it, just put it together. If you're going to leave this building, please leave quietly. The court is still sitting. What are you saying?
Are they not gone down there? Okay. No, we are going down there.
Chief. Bring it here.